Hello, my name is Jed Strong and I'm the owner and founder of Strong Law. Today I wanted to discuss some of the specifics of an auto accident claim in Utah. If you haven't already watched our video regarding the general process of an accident claim, please go and do that. This video is specifically on some of the nuances that are attributable to Utah. So first off, Utah has a 3-year statute of limitations. That means that you must either file your lawsuit or settle your claim within 3 years from the date that the accident happened. Now, the caveat to that is that if your accident was caused by a governmental entity or somebody working for the government, then you have 6 months in which to file a notice of claim. So you have to put the government on notice within 6 months of the accident, and then you have 3 years to file the actual lawsuit from the date of the accident. So another 2.5 years from the deadline of putting forth that notice of claim. So a 3-year statute of limitations with 6-month governmental immunity notice of claim. The next thing specific to Utah is that it requires mandatory PIP coverage of at least $3,000. So that means that if you have a Utah policy, you have to have at least $3,000 of PIP or personal injury protection coverage on that policy. That money goes to paying for medical expenses. It also pays for lost wages. It can pay for help for household services if you need help with household services while you're injured. There is a portion of money that is set aside specifically for those needs. Now, you can get more than $3,000, but the minimum is $3,000, and that's included in every Utah policy. If you're in an accident, you will first use that $3,000 from your PIP or personal injury protection coverage, and that is from your own insurance carrier. Now, on the back end, once the case is resolved, the at-fault insurance company will reimburse your insurance company, but before you have to get involved in any of that, that PIP coverage will be from your insurance company, will pay for it automatically. Now, also, Utah is a no-fault state, meaning that if you even cause an accident and you're injured in an accident that you cause, you can still use that $3,000 in PIP money to start your medical care that you need to get better, even in an accident where you're at fault. But in that situation, obviously, your insurance company would not be reimbursed because you are the at-fault driver. So that's the basics of Utah and PIP, $3,000 mandatory. Another specific item for Utah is the underinsured motorist coverage offset. There is no underinsurance motorist coverage offset, or there is no UIM offset in Utah. So if you recover let's say that you recover $25,000 from the at-fault insurance carrier, and you have $100,000 on your UIM coverage, you can recover that full $100,000 from your UIM coverage. So your total recovery in that case would be $125,000 between the two insurance companies. Some states, the UIM is offset by whatever you get from the liability carrier, but that's not the case for Utah. Additionally, Utah has no damage caps. So if there is an incredibly traumatic injury with lifelong altering effects, there is no limit for the amount of compensation that a jury can award an accident victim in those situations. Some states do have caps, but Utah does not. Utah is also a billed versus paid state, meaning that whatever the bill is from the hospital, even if that bill gets reduced from health insurance payments or something along those lines, the at-fault insurance company is required or responsible to compensate the injured victim for the entire amount of the bill. So for example, let's say you end up in an accident, you have a hospital bill of $10,000. Well, you have health insurance, say through Select Health, and the hospital has a contract with Select Health that they have an automatic reduction. So instead of Select Health paying the hospital $10,000, Select Health will only pay maybe $7,000. And the hospital will have to write off that $3,000 because of the agreement that they have with Select Health. Well, when you go to the at-fault insurance company, you go and say, hey, I have this $10,000 bill, and the at-fault insurance company has to pay that entire $10,000 bill. Now, once you settle the case, you still have to pay back Select Health, but you only have to pay them back the $7,000 that they spent rather than the $10,000 of the total bill. So you benefit from that $3,000 write-off in that situation because Utah is a billed versus paid state. It's another reason why it's very helpful to have health insurance, because you have those contractual write-offs. Another nuance with Utah is that it is a comparative negligence state, meaning that if you are 50% at fault for the accident, then you cannot recover any compensation. So let's say that the total value, let's say that you're 70%, let's say that the other person is 70% at fault for the accident, and the total value of the case is worth $100. Well, then the other person's insurance company would be required to pay $70 or 70% of the value of the claim because you are 30% at fault for the accident. Now, let's say that you're both 50-50, that the other person's 50% at fault and you're 50% at fault. Well, in that situation, you would not be able to recover anything because you have the same level of fault as the other person. And then likewise, let's say you're 70% at fault and they're 30% at fault. Well, there's no recovery in that situation for you because you have more fault than the other driver. And the question is, who determines how much fault goes to each driver? Well, that would ultimately be a jury. And so if your case has a dispute about who's at fault, that's very important to get an attorney involved to make sure that you have the evidence that you can prove that the other person has more fault in the accident than you do. And that specifically comes a lot into play for he said, she said cases. So oftentimes we see cases where both parties claim that the other one ran a red light, and that's if that's all you have, you're going to lose that case because, most likely you will lose that case because it's a he said, she said, and there's no way to tip the scales one way or the other, and so a jury will likely just find 50% fault on that. So on those types of he said, she said cases, it's super important to see what additional evidence you can find. If there's any evidence regarding the metering of the lights, or different witnesses that are available, or other parties' vision can come into play. Did the other person need glasses and were they not driving with glasses? Things like that to move the needle to be more fault on the other party, because again, if it's 50-50, you automatically lose. And another nuance to that is, as the injured party, as the one bringing a claim called the plaintiff, you carry what's called the burden of proof, meaning that it's your burden, it's your responsibility to prove that the other person has more fault than you do. And so if you can't prove that, if you can't actually establish that, then the finder of fact, or the jury by law, has to find that at most both parties are 50-50. So on those liability disputed, who's at fault disputes in an accident claim, I would highly recommend getting an attorney involved immediately. But those are some of the basics regarding the nuances particular to Utah in an auto accident claim. I hope that helps.